Check, check, check. Test, test, test. Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for The Law of Self-Defense. So pleased you are here. So we have some scintillating content to cover today, even though it's in the form of a pre-trial hearing, because it involves Courtney Clenney. Courtney Clenney, the OnlyFans Killer. Courtney Clenney killed her boyfriend, Christian Obumseli, in Miami with a knife to the chest. He was mortally wounded. He bled out quite messily and quickly in the hotel room. She is claiming that she killed him in self-defense, specifically that she tossed the knife at him, and it managed to penetrate 3 inches into his chest and hit important blood vessels that cost his life. The state of Florida does not agree. The state of Florida has charged her with second-degree malice murder, and we're getting closer and closer to her trial date. Now, what I wanted to review with all of you here today was something called an Arthur hearing. Arthur hearings are a thing in Florida involving pre-trial detention. So, Clenney had been arrested. She was being held in custody, not granted bail, and her defense counsel, Frank Prieto, did not like this. He wanted his client out on house arrest with her parents in Texas instead of sitting in a jail cell in Florida. And so he made a motion for pretrial release. The state objected, and that led to this Arthur hearing. So what is an Arthur hearing? An Arthur hearing is set in a court in front of a judge to see if the defendant's eligible to be granted bond or pretrial release. And there's really two distinct parts to this question. The first is a phase one, and it's kind of a mini trial where evidence and witnesses are presented, typically by the state. In this case, it is by the state, and then the defense can cross-examine those witnesses and that testimony, and it turns into a kind of a mini trial in front of a judge. Now, there's no jury here. This is pre-trial, but the judge in this case would be hearing, and it happens to be Judge Laura Sheeran Cruz. She's the presiding judge at this hearing. Now, this hearing took place over a year ago, so in November of 2022. It's quite lengthy. There were two essentially half-day hearings, 4-hour hearings on November 15th, and then again on November 17th, 2 days later. And about 3 weeks after that, the judge issued her ruling, December 8th. Spoiler, she denied release for Courtney Clenney. So Courtney Clenney is still sitting in a jail cell today, awaiting trial. What I liked about this Arthur hearing is that because it is like a mini trial, we get to hear key testimony from key witnesses and also about exhibits and phone records and stuff that we wouldn't otherwise see until the trial was taking place. We get to see it before the trial. And now, as the trial gets closer, I thought it would be a good opportunity for us to take a look at that evidence and testimony that was presented at the November 2022 Arthur hearing, because we can expect to see all of that again at the trial. Now, at this Arthur hearing, the burden of proof is on the state, and it's a pretty high burden. The evidence has to be sufficient to satisfy the judge that there's a great presumption that the defendant, the person charged, is guilty of the crime charged. In this case, that Courtney Clenney is guilty of second-degree murder. It's not proof beyond a reasonable doubt, but it's a lot more than mere preponderance. Obviously, given that this judge concluded that she would not grant pretrial release, she felt that the state had met their burden. Now, assuming that the state had not met their burden, there'd be a second set of arguments to be made about whether or not discretionary bond would be appropriate on the facts, considering things like whether or not the defendant posed a flight risk or a danger to society, and all of that. But the value here for us is in that pre-trial testimony from witnesses that we can expect to see argued again at trial, presented again at trial. So with all that, oh, by the way, because this is so long, it's like 8 or 9 hours total of this Arthur hearing. I've chopped it up. I think it's going to be 5 segments. So we'll see what I can make happen. I'm going to try to fit it all into 5 discrete shows over the course of a week. But in the meantime, we have the formal launch of today's show. Let's go ahead and get that started. All right. So we're looking into the part 1 of 5 of the Courtney Clenney Arthur hearing, in which testimony, evidence is presented in a pretrial hearing in a manner we should expect to see replicated when the trial actually happens. I do want to mention, of course, that today's show has a sponsor. That sponsor is none other than Law of Self-Defense itself. Twice a year, I teach a full-day course on use of force law, self-defense law, defense of self, defense of others, defense of property. It's a full-day course, and you become an expert on use of force law in a single day. You know how to be hard to convict if you're ever compelled to defend yourself, your family, your property, all in one day. Now, I only teach this class twice a year at most, and the next date's coming up, April 20th, Saturday, April 20th, 2024. And we're still in the early registration period. So if you register now, you'll save up to 50% off the standard registration at lawofselfdefense.com/advanced for a full day advanced class. Now, again, if you missed this date, we're not doing this class again until October at the soonest. Can you afford to wait that many months longer before you know how to effectively and lawfully defend yourself from criminal predation? Is the country getting any safer in that 6-month interval? Do you get to decide when you are attacked and when you have to defend yourself, your family, your property? No. The bad guy gets to choose the time, place, and manner of attack, which means you cannot afford to wait. You have to grab this opportunity right now at lawofselfdefense.com/advanced. And by the way, if you have a conflict for that Saturday, April 20th, I would register anyway, because every registrant will also be given access to the playback version, the recorded version of that class for at least 2 weeks after the course, after that Saturday. So even if you can't make that date, you'll be able to participate in the course at your leisure over the next couple of weeks. So don't miss this opportunity. 50% off, only twice a year, Saturday, April 20th. Register now at lawofselfdefense.com/advanced. Okay, now let's pull this up. So this isn't, I'm not going to play the entirety of the Arthur hearing. The first, 45 minutes or so is spent kind of in technical, legal arguing about certain issues, most of which go against the defense. I'm going to stick with the testimony of the witnesses in the Arthur hearing, the testimony we can expect to see at trial. And this is from the November 15th, 2022 Arthur hearing. And the main witness, the only witness, was the lead detective on this case, Detective Brecino. So I'm starting up this Arthur hearing right at the start of his testimony. So here's the state prosecutor on the left. There's Detective Brecino standing up with the red tie. Seated behind Brecino at that little table is Frank Pietro, who's the lead defense counsel. And with him, I believe, is Sabrina Puglisi, co-counsel for the defense. And they'll be doing cross-examination. Well, Frank Pietro specifically will be doing cross of this Detective Brecino. The audio is not great. Not much I can do about that, folks, but we work with. Today's show is sponsored by the Law of Self-Defense, specifically our advanced live online class taking place on April 20th, 2024. This is our full day course on use of force law that makes you hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We cover everything you need to know. Why and how the legal system prosecutes self-defense, the 5 elements of self-defense, the fundamental building blocks of any claim of self-defense. We cover defense of others and defense of property, consciousness of guilt, self-defense immunity. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event, how to craft your own customized, legally sound self-defense strategy, and much, much more. Now, we only teach this class twice a year at most. So if you miss this April course, it'll be at least 6 months before you have the opportunity to take this course again and make yourself hard to convict. Do you know when you're going to be attacked? It's not up to you. The bad guy chooses the time, place, and manner of attack. You need to be ready for both the physical fight and the legal fight before that happens. And register now, and you can get up to 50% off for this April 20th Law of Self-Defense live online advanced course. Don't hesitate. Scan that QR code now, or simply visit lawofselfdefense.com/advanced. Now, before we jump into this first witness, I do want to kind of frame out the legal arguments in this case. The state, no one's disputing that Courtney Clenney caused the knife injury to the chest of Christian Obumseli. That's not in dispute. She concedes she caused the injury. She claims she caused the injury in self-defense, and her defense counsel is presenting her as a victim of domestic violence who ultimately had to kill to save her own life from her abuser, who she claims was Christian Obumseli. The state is presenting quite a different theory of the case. In fact, it's the mirror image of that theory. The state is saying that, in fact, it was Courtney Clenney who was the abuser. It was Christian Obumseli who was the domestic violence victim in that relationship. And ultimately, Obumseli, the victim of that domestic violence relationship, was killed by his abuser, Courtney Clenney. That's what they're characterizing as second-degree murder. And now we're going to hear from the this first witness in this Arthur hearing. Really, he's the only witness for the entire day of the Arthur hearing, and that is Detective what's his name? Brecino, Detective Brecino. And he's going to begin. He's being questioned on direct by the state. The state assistant state attorney here is Khalil. Quinan will conduct a direct, and then he'll be subject to cross-examination by defense counsel Frank Pietro, and then there'll be a little more redirect and recross, and then that'll be the end of Detective Brecino for this. Today's show, Law of Self-Defense show, this first to 5 will just be this direct questioning of Brecino, Detective Brecino, by ASA Khalil Quinan. That's where we are now. So let me pull up Detective Brecino and we'll get started. Just FYI, I will be playing this at 1.25 speed in the interest of time.
Good job. I'll defer to that's what happened. State law detectives, no.
Do you solemnly swear affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do. Good afternoon, Detective. You could introduce yourself to the board.
Detective Yermain Brecino.
Detective, what do you do?
I'm assigned to the homicide unit.
How long have you been there?
A little over a year.
Before that, do you have any law enforcement experience?
Yes.
Can you please tell the court your law enforcement experience?
I've been an officer in the city of Miami for about 9 years, 4 of which I was a detective in the robbery unit, and 1 now currently in homicide.
Do you know a person by the name of Courtney Clenney?
Yes.
Do you see Ms. Clenney in the courtroom today? Okay. Let's talk about how you came to know Ms. Clenney. And specifically, I want to focus you on April 3rd, 2022. Is that the date that you met Ms. Clenney?
Yes.
Did you know her from beforehand?
No.
Having discussed the April 3rd, 2022 day, let's walk through it. Under what context did you first meet Ms. Clenney?
It was at her apartment, just outside. She was detained at the moment.
And let's kind of walk through that. Why did you end up responding to her apartment that day?
I was notified that there was a stabbing, and the victim had been taken to rider trauma and succumbed to his injuries.
So at the time that you met her, you already knew Ms. Obumseli's past?
Yes.
So let's pierce this up. First, you met her at her apartment. Where's her apartment?
Her apartment is at 3131 Northeast 7th Avenue.
Is that Miami-Dade County?
Yes.
So you mentioned you were notified because he had succumbed to his injury. Obviously, that you're a homicide detective. That's how you got involved.
Yes.
And why is it that you're the lead detective?
It was just my turn to take the next case.
So just as a premise, you didn't actually the case. It was just
Correct.
Okay. So you responded to the scene of the homicide. You met Ms. Clenney. What did you do?
Say that again.
What did you do?
We responded to the scene. We began to check the apartment and get in contact with the crime scene. And simultaneously, we had Ms. Clenney transported to the station.
Before we get into what happened at the station with Ms. Clenney, let's discuss the events of the day. Do you know approximately what time police was called out to the apartment?
I don't recall.
Okay. Would anything refresh your recollection?
No, not right now.
Okay. So you're aware that at some point police got called out to the apartment?
Yes.
You've reviewed the evidence, the body cameras, all the evidence in this case?
Correct.
Okay. So what happened when police officers arrived to the scene?
When police officers arrived, they were able to make contact inside the apartment. They saw Ms. Clenney cradling the victim. They were able to separate the two of them, provide aid to the victim while they waited for fire rescue to show up on scene.
And then what happened after fire rescue showed up on scene?
They were able to transport him to Jackson.
And do you remember approximately when Mr. Obumseli was pronounced deceased?
I would have to go back to my notes.
You can refer to the report. Let me know when you remember your question.
At 5:55 p.m.
So 5:55 p.m., he's pronounced deceased. You are dispatched as a homicide detective. We already mentioned that you responded to the scene, initial check of the crime scene, contact with the crime scene, and sent the defendant over to the police department. So far as everything, I guess, per protocol?
Yes.
Okay. When the defendant arrives to the police department, at some point you end up interviewing her?
Yes.
Okay. Now, just for context, did you read her Miranda rights?
I did.
Did she waive her Miranda rights?
Yes.
Was that audio and video be recorded?
Yes.
Okay. And for directing the court to the recorded statement. So I'm not going to belabor the point the court has reviewed the recorded statement, but would you synopsize the defendant's statement for the court?
So she told me that she was at the apartment. The victim had went down to go to Subways. When he went to Subways, they began to message each other, and through text messages, they got into an argument over sharing each other's location. He then decides to come back to the apartment. Shortly after he comes back to the apartment, another argument ensues. At that point, the defendant says that the victim grabbed her by the neck, slammed her against the wall. She was able to break free. Then she was going to call her mother, and he didn't want that to happen, so he grabbed her and put her onto the ground. She wasn't able to explain how exactly that happened. After that, she was able to break free once again, at which point she goes to the kitchen. She grabs on a knife, and then she states that the victim ran towards her, and that's when she flung the knife or threw it, and it hit him in the shoulder.
What did anything besides that? Did Ms. Clenney say anything besides that condition of substance, I guess, regarding the incident?
No.
So regarding the injuries,
Yes.
in this circumstance,
Yes.
I want you to tell the court, I guess, how you're evaluating the case. Where are you in your analysis of the facts thus far?
At that point, we were looking at it as a self-defense at first, but then later on, things started revealing that it wasn't what we thought.
So let's talk about that. So at the point in which you finish interviewing her, despite some of the inconsistencies in the statement, you are evaluating the case for a possible self-defense claim.
Correct.
Is that one of the reasons why you document how she looks in her injuries?
Yes.
Okay, so let's parse through that. Did you have crime scene take photographs of her?
Yes.
And I'll direct the court just as general reference to the crime scene photos. Were there bruisings on her?
Yes.
Okay, will you tell the court whether there was bruising?
She had some bruising over on her legs, She had some small bruising to her arms, and that was about it.
Okay. Do you have experience in seeing fresh bruises versus old bruises?
Yes.
Okay. Have you, in this context, right? Just as a human, have you seen bruises?
Objection, Judge. Lack of discussion, lack of predicate your opinions. Judge, I believe that the state intends to try to elicit some kind of expert testimony from a detective regarding bruising. That's clearly the purview of an expert. And this, as far as we know, this detective has no medical training. He's not a doctor. He's a detective. So I object to him making any opinions as to when bruises were formed.
So there's a lot of parsing to that, and he's not issuing an opinion as to when a bruise was formed. He's issuing an opinion as to whether it's a new bruise or an old bruise. As human beings, we know what bruises look like in an older bruise versus a newer bruise. Older bruise is darker versus a newer bruise, which is lighter coming into.
I'll object to the counsel testifying as well, Judge. He's not an expert either.
Judge, can we approach that part very briefly?
She's claiming self-defense. She had bruises on her legs. The state has evidence that she had bruises on her legs days earlier from photographs of her out dancing. So those bruises could not have been caused, the state will argue, by this event. She was not, Obumseli was not inflicting bruises on her, injuries to her legs this day. They were already present and so couldn't play a role in a self-defense narrative here.
Judge, just as a separate preliminary matter, I believe the evidence was accepted by the court, and if it hasn't, I'm just moving all of the state's exhibits into evidence.
No, other than the students.
And I'll just refer to them as their sub-exhibits, and I believe in evidence there's state's exhibit 1 for 1A. Continuing, did you see bruising?
Yes.
Okay. And that bruising you mentioned it was on the arms and the legs.
Yes.
Did you see any bruising on her neck?
No.
Did you see any hand marks on her neck?
No.
Did you see any bruising coming in from her neck?
No.
Did you see any bruising consistent with her having been grabbed by the neck?
No.
Did you document the area of her neck?
Yes.
And are those, I guess, the photographs that were documented by forensic?
Correct.
You had an opportunity to review Mr. Obumseli's cell phone extraction.
Yes.
As part of that extraction, did you see videos from the same day but earlier before the murder?
Yes.
In those videos, did you see bruises on Miss Clenney?
Yes.
You also had an opportunity to review the Instagram Live video that she posted between Mr. Obumseli leaving the apartment and returning.
Yes.
Did you had that opportunity to review that video?
Yes.
And in that video, did you see the bruising on her?
Yes.
Now let's speak specifically. Let's speak specifically about those bruises, right? Let's separate arms versus legs. The bruising on her arms, were you able to see them in the Instagram Live video?
Yes.
And again, that video was posted before this murder occurred.
Correct.
So those bruises were before the murder occurred.
Yes.
Let's talk about the legs. You saw bruising on her legs in the earlier posted video of her dance.
Yes.
In that video, are those the same bruises you saw later that day?
Yes.
So, and then the metadata of those videos were like 10, 11 in the morning same day.
Yes.
So let's continue through this. You mentioned that Miss Clenney,
That was YouTube.
told you and showed you how she threw the knife or flung, as you said, at Mr. Obumseli.
Yes.
Would you please reenact to the court the manner in which she claimed she threw this?
This is good.
She said she put it over her shoulder and then she just flung it forward.
And I'm just noting, if we're going to talk about the record, right? So you're saying that she got her arm back and threw it forward.
Yes.
And I guess just as a parallel, it's kind of like a football.
Yes. Correct.
It was not a fling using like a flick of the wrist.
Correct.
Okay. So after you interviewed, actually before I move on from that, did she tell you the distance in which she flung the knife?
Yes.
Okay. What was the distance that she told you?
She said it was about 10 feet apart.
Did she point to the room?
Yes.
Okay. What was it that she said when she pointed to the room?
She said the distance was bigger than the room that we were in.
And so in that context, as if the room was 10 feet, it was longer than 10 feet.
Yes.
So she was at a distance of approximately 10 feet when she claimed she had flung this knife.
Yes.
And did at any point she say whether Mr. Obumseli was armed?
No.
No.
He wasn't armed.
Okay, so she did say, but he was not armed.
Correct.
So she acknowledges Mr. Obumseli was not armed in excess of 10 feet from her when she threw this knife in.
Correct.
So progressing from that, during the interview of the defendant, you became aware that she was on the phone with her mother during the incident.
Yes.
What did you do as a result of that?
As a result of finding out that she was on the phone?
Yeah, after knowing that she was on the phone with her mom, and then you finished the interview, what did you do?
I was able to get in contact with the mother over the phone.
Okay. Did you do an audio recorded interview of Miss Clenney's mother?
Yes.
Okay. Were you aware that there was anyone present besides you and your fellow detective on that call?
No.
Okay. At what point did you become aware that there was someone else on that call?
When the attorney arrived at the station, her father spoke from on the same call, saying that the attorney was there and that they would like for the attorney to be present for any more questions.
So during the length of your interview with her, you were not aware that she was with someone else in her person?
Correct.
As you were doing.
That's relevant because it suggests consciousness of guilt. They're being surreptitious about their participation on this phone call, and is that what a lawful person would do, or someone who thinks they're guilty?
During that interview, what did you ask Mrs. And I'm directing the court to the audio recorded statement as an evidence, but again, will you please synopsize the contents of that call?
We spoke about the relationship between the victim and the defendant. And she explained to me that I believe it was about a week before the incident that the mother was there for 6 days because Christian wouldn't leave the house and he kept following her around. So she came down to Miami to see if the transition of him leaving the apartment would be a lot better than just them two trying to figure it out.
That's YouTube doing that, folks. It's not a great effort by YouTube on this one. Yeah, the timer is clicking. I'm skipping forward. Yep. Skipping forward. There we go.
Nothing more than that.
Correct.
Mrs. Clinton didn't say anything about outlet hurts or any indication that the defendant was injured in any way.
Correct.
Did Mrs. Clinton tell you the circumstances of the incident, how she knows the incident occurred or under what circumstances?
On the day of?
Yeah.
No.
Okay. At any point did she tell you she knows what happened?
No.
So having moved on from that, earlier we talked about how you were evaluating the case for possible self-defense.
Yes.
So what did you do as a result of, on the date of the incident, what did you do as a result of where you were at?
I don't understand.
In a nutshell, after you interviewed the defendant, you interviewed the victim,
Yes.
or rather you interviewed the defendant, you interviewed the defendant's mother, crime scene, photographed the scene.
Yes.
They documented her, you collected all pieces of evidence. What else happened that night?
Nothing else. We finished with the scene and the defendant was let go.
Okay. Is that normal protocol?
Yes.
Okay, why is that normal protocol?
At the time, we didn't have enough to say what actually did occur, and we still needed to continue the investigation.
Had a decision been made as to the defendant's criminal culpability at that point?
Well, at first, I was leaning more towards a self-defense.
No, we discussed that. My question was,
yes.
did you close the case and say it was self-defense, or was it still open?
No, it was still open.
Okay.
Yes.
So the investigation was still open, it was still pending. Okay, so what are the next steps you took in your open investigation?
Okay. So we did several warrants for everybody's cell phones, the victim and the defendant's cell phone. We did warrants for social media, and yeah, I believe a couple of other warrants as well.
As a result of some of these warrants, did you end up briefing the city attorney's office about the investigation?
Yes.
Okay. As pursuant to that briefing, were there subpoenas that were sought?
Yes.
Okay. I'm just going to go through things that are in evidence, but did you obtain police reports and body camera from Las Vegas?
Yes.
We're going to talk about this. I'm just going through it. We mentioned warrants. You said on the phone. Which phones are you speaking about?
I'm speaking about the victim's cell phone and the defendant's cell phone.
Okay. Were you able to get the extraction from the victim's cell phone?
Yes.
Were you able to get the extraction from the defendant's cell phone?
Not yet.
Is that still pending and being attempted?
Yes.
From the extraction, were you able to obtain data and information?
Correct.
Okay. So we'll cross that bridge in a little bit. Pursuant to subpoenas, were you able to obtain surveillance footage and incident reports from one party, so condominium?
Yes.
Did you also obtain lease documents?
Yes.
As part of those documents, were you able to obtain the fob records?
Yes.
You mentioned
The fob records have to do with they used a key fob like you might use for a car to gain access to their apartment, to operate the elevator in the apartment building. So you can tell when people are going in and out by the fob records.
warrants on social media. Was that the Instagram warrant?
Yes.
And is that helping know the precise time in which Ms. Clenney was live?
Yes.
Did at some point you obtain the call detail records of Ms. Clenney?
Yes.
Or the defendant, sorry. Even though I lost myself on that. At some point, did you obtain the criminal history of the defendant?
Yes.
At some point, did you obtain, pursuant to subpoenas as we were discussing, financial records belonging to the defendant?
Yes.
Now let's go back again. Date of incident, crime scene process. At any point, did you obtain a diagram of the apartment?
Yes.
Was that diagram to scale and measured and documented?
Yes.
Just noting for the court, Exhibit 19. Will you please describe to the court the crime scene? Again, it requires the photos, but just outline it for it.
Okay. The crime scene is an apartment located on the 22nd floor of the One Paraíso building. It's a 3-bedroom apartment with a single kitchen and living room. You want me to explain also where the scene was located? Or?
Yes, please, if you don't mind. So let's parse that through. And actually, let's take steps in this. When crime scene enters an apartment,
Yes.
we tell the court the various photographs that they take, such as the
Yes.
initial scene, the measurements, and so on.
So before anything is done, we take all photographs from the first floor of the building to show what building we're going to. The elevator, the floor of the elevator that it stops on, the number that's fixed to the front of the apartment, the front door, and then all wide-angled and far away photos of every room in the apartment. And then initially they started taking photos, closer shots of any blood or weapons or anything that has to do with the incident.
Will you please describe to the court I'm going to separate them into 3.
Yeah.
There's the 3 different blood scenes.
Yeah.
Will you please explain to the court what that means?
So the first one that we find is where we initially found the victim, which is the first puddle of blood. The second one was more towards the living room. And then the third one was, it was more between blood spatter and droplets that were moved around through, well, not moved around, but showed that the victim was walked around the apartment.
Objection, Your Honor.
So let's piece through that. So there were 2 pools of blood, which is 1 and 2 that we just discussed, and then the third where there was droplets and spat.
Yes.
You described this one, I'm just noting for the record. The first pool of blood is where the defendant was located,
Yes.
holding the victim. The second one you said was further back And it was just a pool of blood.
Yes.
Did you see blood transfer on the wall?
Yes.
Okay. What does that blood transfer mean?
Well, it can mean numerous things. But the one on the wall was it means that it's blood spattered, meaning.
No, I'm talking about the transfer. So
okay.
The second pool of blood, if you recall, there was, again, I'm just noting the exhibit as an evidence. There was blood on the wall.
Yes, I remember.
And it was kind of filled. It wasn't spattered or dropped. Do you recall that?
Not so much.
That's fine. Then we'll move on if you don't know. So let's talk about the blood spatter and the droplets.
Objection, lack of predicate.
If the defense pushes too hard on this kind of stuff, this is not in front of a jury. This is just in front of a judge. The judge understands the evidence. There was a great deal of blood, as you might imagine. I believe it was the aorta that was nicked, and the blood just comes out like it's coming out of a high pressure hose.
So we were last left off on the spatter and droplets. Do you know what spatter is? Like, just can you describe that?
Yes, spatter is more of a way that the blood kind of like just if you stab somebody or you
That's not real.
if you swing any type of liquid, it makes a certain movement that it shows that the blood was traveling at a certain direction.
So how is it different from a drop?
A droplet is it's
Objection.
I'm not asking conclusions.
I believe it's the
Sure.
what is salt, and to at least some succeed.
Okay. Did you see droplets throughout the house?
yes.
What does that mean?
Means that there was blood following straight down at a straight angle.
Objection.
Okay. And where did you see these droplets?
In the living room heading towards the bedroom, the master bedroom.
Just going back about the flinging of the knife. Do you have any information that the defendant knows how to throw a knife or is some kind of expert in throwing a knife?
No.
At any point in time, did Christian Obumseli go to the medical examiner's office?
Yes.
Was an autopsy performed on it?
Yes.
Have you reviewed the contents of that autopsy?
Yes.
Okay, let's discuss that autopsy. Who was the medical examiner that performed it?
Dr. Hutchins.
Okay. As a result of that autopsy, did he determine a manner of death?
Yes.
What was that manner of death?
By stabbing.
Okay. Did he rule the death in any particular manner?
No. Oh, I mean, yes. Homicide.
Okay. At any point in time, did you become aware that it was impossible to have thrown the knife, or at least that was the opinion?
Objection.
Just asking.
Can you repeat the question?
At any point in time, did you become aware that the throwing of a knife could not have caused an injury?
Yes.
Approximately when? Where were you in your investigation?
The throwing of the knife could not have caused that injury. Now, of course, I imagine the defense is going to object to that because that's a little awkward for self-defense. He was 10 feet away by the defendant, Courtney Clenney's own testimony. Too far to be inflicting damage upon her. He doesn't have arms that are 10 foot long. She says she threw the knife, not that he closed on her and she stabbed him. She threw the knife 10 feet and didn't really mean to hurt him, but somehow the blade sunk in 3 inches, hit his aorta at a downward angle as if you were plunging a knife downwards, like Psycho, the movie. All right, that's where we're at here.
I was later on in the investigation.
So let's talk about some of the other evidence that you obtained. So we discussed Las Vegas. Did you get a chance to receive those reports and review them?
Yes.
Just directly report to the Las Vegas reports. At any point in time, did you review the body camera?
Yes.
Not to belabor the point, but will you please send outside to the court what was in those reports and in the body camera?
In the reports that explained that the victim and the defendants were staying in a hotel room in Las Vegas. They got into an argument. Through that argument, the defendant threw a bottle of water at the victim while he was laying on the couch. And security was called to the apartment due to the argument.
Did you review the defendant's statement?
Yes.
To Las Vegas?
Yes.
In that statement, what did she say?
She says that she likes to throw things, and that she guesses that she was the one that threw the bottle at him.
Did she acknowledge throwing items at Mr. Obumseli before?
Yes.
What were those items?
Plates and other items.
Was Mr. Obumseli interviewed?
Yes.
As part of that interview, did there come a time where the officer asked Mr. Obumseli a bunch of questions as to whether the defendant was violent with him prior to that?
I can't remember that right now.
Sure. I'll just direct the court to the video. Following the defendant's admission, was she arrested on that case?
Yes.
Okay. Let's talk about the cell phone extraction. Did you get a chance to review Mr. Obumseli's cell phone extraction?
Yes.
Will you please tell the court what a cell phone extraction is?
It's pretty much just an extraction of all the data, messages, photos, videos, and even sometimes social media saved posts can be extracted from the phone.
During, I guess, when you received the extraction from his phone, did you get an opportunity to review the photographs?
Yes.
Did you get an opportunity to review the videos?
Yes.
Did you get an opportunity to review the text messages between the defendant and Mr. Obumseli?
Yes.
I want to discuss with you regarding your review of those, and I'm going to bear with me because I'm just going to be very specific in directing it. You have all the records, just so we're clear.
Yes.
When they're produced, they produce in the PDF. How do they come out?
They're produced in a PDF.
Do you recall how many text messages there were?
It was over 12,000. I believe it was 12,220. Something like that. Yes.
Do you remember from when to when those messages were?
Yes. Those messages go back as far as 2020.
Okay. You remember when? November, December, January?
I can't remember the month.
So from 2020 to April 3rd, you have the complete messages into 12,000 or so.
Yes.
Let's discuss the messages from, just going to be very delicate. October 9th through the 11th, which is in evidence of Exhibit 4. Did you get a chance to review those?
Yes.
Will you tell the court, again, just a synopsis because the court has them, what is covered in the messages between in State's Exhibit 4?
Mind if I review my notes really quick?
Yeah, if you need to refer to anything to refresh your recollection, go ahead and then let me know when you're ready.
All right.
What was discussed on the October 9th through the 11th message?
So, based off of the messages, there was an argument that occurred again. Mr. Christian writes to the defendant that she stabbed him, and he wants to get into the room, that he needs help, and she pretty much just told him, go get first aid.
Just to be clear, everybody, what they're talking about now is a prior stabbing event, prior to the day of the fatal stabbing. So the day she killed him was not the first time she ever stabbed him.
and pretty much just brushed them off.
Later on in those messages, does he confront her about hitting him with a phone?
Yes.
Okay. Does he confront her about her spitting on him?
Yes.
Was it in the context of all of these messages where he also confronts her about that?
Yes.
Did the defendant respond to these accusations from Mr. Obumseli?
Yes.
What did she say in response? You can review your notes yet.
Yeah, she pretty much just tells him to go get first aid. And then for several hours, she just didn't answer anymore till the next day.
At any point, does she apologize for her actions?
Yes, the following day.
And does she do it in the context of acknowledging the accusations?
Yes.
In those messages, were there any affirmative allegations by her to Mr. Obumseli?
Yeah, she pretty much told him that she apologizes. She shouldn't have treated him that way. She shouldn't.
Let me cut you off. You didn't understand my question. My question was, did she make accusations about Mr. Obumseli? So, for example, he sent her a message about you stabbed me.
Yes.
Did she reply saying, well, that was because you were choking me?
I can't remember right now.
Did she make any accusations towards him at all in those messages?
She did, but I can't remember the specific accusations.
Let's talk about January 30th to February 1st. Did you review messages from that incident?
Yes.
Okay, will you tell the court what that incident is about? That's Exhibit 5.
On those messages, the defendant was trying to reach out to the victim, and he pretty much just said, "Yes, Courtney." At that point, she didn't like the way that he wrote to her, and just started becoming very angry and asking him about why he said, "Yes, Courtney."
Were there audio messages associated with that?
Yes.
At any point in time, did he communicate to her that he had made a mistake because he was doing something?
Yes.
Okay, what was it that he communicated to her?
He explained to her that he was just trying to answer quick because he was watching the overtime on a football game.
Okay. Do you know what overtime he's speaking about?
I believe it was the Bengals versus the Chiefs.
Okay. And so you're referring to the overtime of that?
Yes.
So at any point in time, was there, I guess, did the messages continue, or was there a break in time between those messages?
There was a break.
Okay. At the end of the, I guess, argument over the tone of the messages and the next message, what is the next message that occurs in that break in time?
May I go back?
Sure. What was the first conversation after?
So the first one that I recall, it was the defendant telling him, "I hope this gives you time to think about what you've done." And then she tells him, "Enjoy the hospital." And then after a little while, he messages her, "I lost a lot of blood. Can you come? I need you." And then she asks him, "Are you having fun?" And this is all between him writing her that he's losing a lot of blood and at the hospital.
Okay. Were you able to find out what happened in that time period?
Yes, she ended up cutting him with a knife.
Okay. Now, how did you figure that out?
It was all in the messages that he wrote, and she responded back to him.
Were there also photographs from that date and time?
Yes.
And how is it that you figure out the date and time that a photograph is taken from the device?
So through the properties of the photo, it will show you when the photo was created, and it was at the same time and date as these messages were sent to him.
And just so we're clear, the messages had or the photographs also had location information.
Yes.
Do you remember where the location of that was?
It was on the east side of the 195.
Okay. Is there a street that's there?
Yes, that's called the Julia Tuttle, but it leads up to the hospital. It was just it was pinpointing right at the hospital, Mount Sinai.
Okay. The state's directing the court's Exhibit 6. So in those photographs, you said it shows that his lip was sliced.
Yes.
And that the location of those photographs were at a hospital.
Correct.
Were you able to locate images of those injuries?
Yes.
Okay. Directing the court to Exhibit 7. Will you just describe to the court what those injuries were?
It was a large laceration that goes from the lip to the bottom of the chin.
Okay. And what is the laceration?
Say that again.
What is a laceration?
Laceration is it's a cut.
So there was a large cut from
Yes.
the chin to the lip.
So she took a knife to his face. This girl took a knife to that dude's face. He's much physically larger than him, but she went and she found him and she cut his face with a knife. Crazy.
And there were stitches, you said.
Correct.
Did he appear to have any other injuries in that stitches photo?
Yeah, he had another small laceration here to the left. I believe the left of the face,
For the record, you're pointing
to the
like a
closer
cheek.
to the chin, to the cheek.
Okay.
As well as we noticed that on the photo with the stitches, he had 2 black eyes, or what you would call raccoon eyes.
Okay. So there was dark discoloration on his
Yes.
face, by his eyes.
Correct.
And then at any point in time close to these incidents, was there another selfie of the defendant for comparison?
Yes.
Or not defendant, excuse me, the victim. States Exhibit 8 for the record. Were there more incidents documented in text messages?
Yes.
Okay, let's discuss February 27th and 28th.
Okay.
What was documented in text messages there directing the court's exhibit 9?
Can you go back really quick?
Sure, you can look at your notes. All right, sir. What was discussed in the February 27th and 28th text message?
So during that time, the victim, he wrote a very large message to the defendant. He pretty much started explaining is love gonna kill him. Through that message, he explained how the defendant has stabbed him several times, hit him with the phone, with other items, calls him the N-word on several occasions. And in regards to hurt him, he says that he has tried his best to work through it, and that after he goes through, after he starts his seeing a counselor, a psychiatrist, that he's gonna leave her. But then he also went into explaining that if she was still willing to work through it, that he would still want to work through it.
Following this, did the victim begin documenting audio and video recording incidents between him and the defendant?
Yes.
Were there any of these documented incidents before this text message? This lengthy text message?
I
mean secret recordings, right? He
Yes.
started
Yes.
recording.
Yes.
Prior to this text message, did he secretly record it?
Yes.
Okay. He did?
Yeah.
Okay, when did he secretly record it before this?
I can't remember the dates.
Okay. After this date, for certain, he did.
Actually, let me review.
Sure, go ahead. If you need to review your notes, refresh your thoughts.
I don't have those with me right now.
So you said you don't have them, as in, does that mean that you're not sure if you recorded her before?
Correct.
Okay. So you're not sure if you recorded her before February 27th, 28th, but you're certain that you did after?
Yes.
Just directing the court to States Exhibit 11 and the court's prior rulings. Sir, you're aware of a series of videos that state sentence evidence that was discussed earlier.
Yes.
I'm not going to kind of publish those in here because the court has already had them, but would you just generally describe those 3 videos?
So on one of the videos,
Everyone's up at the bench.
The same to just repeat, remind you of which video I logged in.
Okay.
And one that Okay, let's get to this. About 5 minutes. We'll let everybody take a break. So, possibly.
So, Detective, as we're talking about, Safety Exhibit 11 includes 3 videos and metadata of 4 videos.
Yes.
Those 3 and another one. Again, court has Safety Exhibit 11, but for purposes of our record, we just described generally the 3 videos that were entered into Safety Exhibit 11.
So one of the videos, they're in the lobby, and the victim had just explained to her, like, why are you hitting me? You can't be hitting me like that. And then she lowers her voice and tells them, shut the fuck up, bitch. And then he continues to ask her, why are you doing this? Like, calm down. And that was the end of that video. The other video, she was having some sort of a tantrum in the apartment and yelling to the top of her lungs. And at one point, she calls out names using the N-word towards the victim. And she also even tells him, "Come here, let me slap you." And then also continues into telling him, "Find my phone, get me alcohol, get me alcohol."
During those recordings, did she also express, I guess, a jealousy of anybody?
Yes.
Okay, will you please explain?
She, according to the video, he acknowledged somebody in the lobby or just in front of the building when he went out to I believe it was to walk his dog. And he didn't tell her that he acknowledged somebody downstairs. And then that's when she just went into this continuous screaming for several minutes.
Now that we've discussed that context, I want to talk about building-specific incidents at one priority cell and how they document these incidents. Did you receive a lengthy amount of records from them?
Yes.
Do you remember approximately how many pages?
Too many pages.
Too many pages. Okay, fair enough. As part of that, did these reports contain with them photos, videos, audios?
Yes.
These photos and videos, will you describe them to the court how they look on these reports?
No, I can't remember too much about the
Sure.
those records.
Were these videos and photos and audio recordings, were they original or were they like pictures of videos and things like that?
If I can remember correctly, they were original from the actual video.
And are you referring to a February 21st incident?
Yes.
Okay. Again, that's stated to the 10 I'm directing the court to, but will you please describe it for the court again for our records?
So at one point, the defendant walks downstairs or takes the elevator downstairs. Shortly after, the victim goes downstairs as well. Several minutes later after that, the victim comes back to the elevator. It opens, it closes. I guess he went to go back to look for the defendant. Eventually they come back. She enters. Then she's trying to click on on her floor, but she can't because she doesn't have the key fob. So
Hey, folks, I'm going to interrupt this Arthur hearing testimony of Detective Brecino because he's talking about the infamous elevator fight. And of course, we have separate video of that, and they don't show the video during the hearing. So I thought this would be a good opportunity to share it with all of you. Of course, the judge in the hearing is aware of the elevator fight, but I thought this would be a good place to insert it to refresh everyone's recollection, or if you haven't seen it yourself. So this is the elevator video that Detective Brecino is referring to right here. There's no audio in it, but you'll see the interaction between Courtney Clenney and the victim. All right, and that's it. With that played, let's get back to the Arthur hearing testimony of lead detective Brecino on the Courtney Clenney second-degree murder trial. Here we go.
The victim comes in. He's trying to put on the key fob, and she begins to attack him, pull his hair. She at one point tries to swing at him with a closed fist. So he ends up kind of like holding her down so he can use the key fob and go back upstairs to their respective floor.
Let's parse that through. You mentioned earlier about having received the key fob and directing the court to Exhibit 13. How many key fobs did that apartment have?
2.
Okay. Do you recall which one was Christian's?
Yes.
Okay. Which one was Christian?
Christian's is the one that ends in it's 01027.
And then and that's the serial number.
Yes.
Okay. What was Courtney's key fob?
It was 01058.
Okay. How can you tell which one's key fob was whose?
So the defendant's key fob has been inactive because she lost it, and it's been inactive since as of I believe it was March.
So February 21st, she still had it.
Yes.
And how do you know that she lost it? Was that a message?
It was in some of the messages.
Okay. So both Christian and Courtney had key fobs.
Yes.
And so she lost it in March 20.
Yes.
Or rather March of 2022.
March of 2022.
And so February 21st, 2022, she still had the phone.
Correct.
Let's walk through that video. When she enters the elevator right before Christian does, is she holding the door or is she trying to close the door?
She's trying to close the door.
Okay. At any point does she put her hand over the door?
Just before he made it.
Okay. So she had her hand over the door right before he entered?
Yeah, right before he entered, she put her hand through the door, or on the side of the door, so it can stay open as he walks in.
Okay. And you did go to this apartment?
Yes.
So that door has a sensor?
Correct.
In the video, you said that you can see her tapping the screen.
Yes.
Did you, again, having been in the apartment, you saw how that system is set up?
Yes.
Are you familiar with it?
Yes.
Okay. So her tapping the button, would that have achieved anything?
No.
Okay. Why not?
Because you need to scan the key fob first in order to be able to go to your floor.
So then you said that Christian walked into the elevator and kind of told her to stop banging.
Yes.
What did he do then?
He was trying to tell her to stop. She begins to swing at him and try and pulling his hair. So then he kind of like pushes her to the side to try and use the key fob. She continues to jump on him to attack him some more. So at which point he kind of like just holds her down, like bends her over and holds her down so he can finally hit the key fob and click on the right floor.
At any point in time, did Christian exercise, I guess, affirmative violence towards the defendant?
No, he's just more trying to like keep her away from hitting him while he gets upstairs.
Now, date of incident, you received the surveillance video too from the building.
Yes.
Besides capturing Christian leaving, returning, and so on, did the surveillance video from the building capture anything?
I'm sorry, say that one more time.
Besides capturing Christian leaving and then returning, did the surveillance video capture anything about this incident, any violence or anything else?
No.
1 second. Your Honor, there's some testimony that I would elicit that pertains to phase 2. I guess my question would be whether the court wants me to go into that now or wait. Sure. At some point in time, we mentioned.
So the state attorney was asking about phase 2. Remember, this is an Arthur hearing, so there's 2 phases. The first phase is a mini trial. You have witnesses come in and testify. That's what's happening now. Assuming that the state meets its burden of a great presumption that the defendant is guilty, the next phase is to determine whether or not, for example, the defendant's a flight risk. And that's where this attorney would present evidence about the defendant's money, attachments to Florida, whether or not she could easily flee, all that kind of stuff. But that's phase 2 stuff. So he was just asking the judge, do you just want me to stick to the guilt arguments now? Or do you, phase 1, or do you also want me to get into the flight risk stuff from phase 2 as well? And the judge is saying, just wrap up phase 1 here, and then we'll take a break. And after the break, we'll have the defense will begin cross-exam, but that'll be tomorrow's show. Let's finish this up.
How the initial impression of the incident was that it was a possible self-defense, and for the last 45 minutes or so, we've been discussing all the subsequent investigative steps.
Yes.
Did the subsequent investigative steps change your outlook of this case?
Yes.
Okay. How did it change?
It changed the fact that I learned that Christian was always the one trying to calm the situation down. Based off of the messages and everything, he was always the one that ends up getting hurt. And the defendant is just the one that's always unable to control herself and hurt him.
As a result, you applied for an arrest warrant?
Yes.
Was that?
Yes.
Noted directly in the court safety exhibit 1. As a result of that arrest warrant, were efforts taken to locate Miss Clenney?
Yes.
Who assisted in locating Miss Clenney?
The marshals.
Okay. Why were the United States Marshals asked to locate Miss Clenney?
Because she was out of our jurisdiction.
Okay. Where was she?
In Hawaii.
Okay. Do you remember where in Hawaii?
Hilo, Hawaii.
Okay. Did as a result of her arrest, did you travel?
Yes.
To Hawaii?
Yes.
How long did it take you to travel?
It took me about 24 hours to get there.
Okay. How many flights?
3.
And actually, before we go too far down the trip, when you received the one Brecino lease records, did you receive a letter documenting the defendant's move out?
Say that again?
Did you, within that packet, was there documentation about the defendant moving out of the apartment?
Yes, they were in the process of
Okay. Did the records document that she moved out April 28th?
I don't remember.
I'll just direct the court to the exhibit for the record 28th. So the defendant had moved out of Miami, was located in Hawaii. Because she was in Hawaii, actually, let me back that up. Do you know how she was located in Hawaii?
No, not really.
So she was located in Hawaii, was apprehended in Hawaii, and extradited to Miami. Did you, I guess, as a result of this investigation, were there subpoenas that were prepared obtaining the defendant's financial records?
Yes.
Okay. Let's discuss those financial records. Have you reviewed them?
Yes.
Okay. Directing the court to the financial records, which I believe are states exhibits 29, 30, and
I guess they're going to do phase 2 stuff now. The flight risk
you at
stuff.
any point in time get a chance to review those records.
Yes.
Approximately how much, and then states exhibit 32 is Bank of America records. Did you get a chance to review that?
Yes.
During that time, immediately before the murder, approximately how much money did the defendant have in the bank account?
I believe she had just over $2 million.
Down just to direct the court to the exhibits, but roughly. At any point in time after the homicide of Christian, did the defendant make transfers of that money?
Yes.
Okay. Please tell the court.
She made 2 separate money transfers over to her father's.
And that was 9 days ago?
Yes.
Did she make any other transfers after that, if you recall?
I don't recall.
Besides those large wire transfers, we discussed briefly earlier, we discussed the defendant's criminal history.
Yes.
Will you please tell the court the defendant's criminal history, directing the court to Exhibit 25?
Well, she has the battery out of Las Vegas,
Okay.
and then she has DUIs out of Texas, and then I believe also out of California.
Did the defendant, so let's talk this through, right? So she has a 2015 DUI from Texas, and then you said it's something from California.
Yes.
Was the California case, did she pick up that case while the DUI was pending, the first one?
Yes.
And then you said she had a second DUI in Texas, and then for the record, it's September 16th in 25. Did she pick up the domestic violence battery in Las Vegas while that case was pending?
Yes.
Do you know if 2020 DUI still in Texas?
I believe so.
And do you know if the defendant has a warrant for that case?
Yes.
One second. And just to finish up, the wire transfers from from the defendant's account to her father, did that essentially deplete her bank account?
Mostly, yeah. She just left some money for herself.
Say another question.
All right, folks. So that is it for direct questioning of Detective Brecino, lead detective on the Courtney Clenney second-degree murder prosecution of Christian Obumseli back on April 3rd, 2022. This is a pretrial Arthur hearing that's to determine whether or not she should be granted pretrial release. Spoiler, the court denies the pretrial release. But the useful part of this is we interview some important witnesses like this detective, and in another hearing a couple of days after this one, the medical examiner. I'll cover that one too. And that provide testimony that is testimony we can expect to see at trial. So it gives us kind of a sneak preview into the state's witnesses' evidence against Courtney Clenney that we should expect to see in trial. Right now, she looks crazy. As this detective just summarized, she looks like she's incapable of controlling herself. She's always the one who's violent. He's always the one that's injured. She's the one that's hot-tempered. He's the one that's trying to calm things down. She actually went and found him when he was watching a football game someplace. She was upset that he wasn't giving her enough attention. She went and found him and cut his face from his lip down to his chin with a knife and gave him 2 black eyes. So the knife injury that cost him his life at the hands of Courtney Clenney was not the first time she stabbed Christian Obumseli. And she taunted him after that first stabbing. Hopefully now that you're in the hospital, this will give you time to think about your behavior. That kind of stuff. Certainly sounds like Courtney Clenney is utterly unhinged, despite looking like this, or maybe because she looks like this. Who knows for sure? Of course, she looks a lot different. She looks a lot different in this photo than she does in Prison Orange, for sure. But that's where I'm going to leave today's show. So take this in, I want to take this because this is 4.5 hours of testimony. This November 15th, 2022 Arthur hearing, Tuesday, November 15th. On Thursday, November 17th, we have another 3.5 hours of Arthur hearing. And then 3 weeks after that, we have the judge deny the pretrial release. But to keep it all in bite-sized pieces, I'm going to pause this here at the end of direct. Tomorrow's show will begin with the cross-examination, about an hour and a half of cross-examination, which I'll speed up for purposes of playing it back. Cross-examination by Frank Pietro, the lead counsel for Courtney Clenney in this case. He seems like a good lawyer to me, Frank Pietro. He's aggressive, zealous for his client. Unfortunately, the facts he has to work with are pretty bad. One of the things we'll see him do tomorrow is kind of scoff at this detective who got a free flight to Hawaii out of this investigation. Isn't that nice? Like that was up to the detective. All right, folks. Well, at this point, I will just remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, tomorrow, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.